proposed set of rules, and they have state legislators and only state legislators working on vetting those rules. And so the day the convention starts, their slate of rules will be proposed, and they're going to have the votes wired to pass that day. That's the plan. It's the plan we're working. And we've got the Republican state legislatures have the votes to make that happen. So the short answer is probably what will happen is if states send way too many delegates for the average, there'll be a limitation on how many can speak or how many people from each state can speak on an issue. So that you don't get California sending 50 people and filibustering everything. It would be one state, one speech rule would probably come into play after a while. But on voting, it's really clear. California's going to get one vote no matter how many people they send. Let them send their entire state legislature if they want. Fine, they get one vote.
It's my understanding that a number of states have, what are they passing, resolutions or statutes?
Applications is the
Applications. Number of states have passed applications, and there seems to be a debate now because some have supposedly rescinded their applications. And there seems to be a debate if they can or cannot rescind their application. What's your opinion on that?
I've litigated the question, and the states can. That was in the ERA case. We litigated whether or not states could rescind their ratifications. And the answer was, yes, they can. And so the people that were quoted in the Fox News article about this, Michigan was the 34th state that passed some form of a balanced budget amendment initiative. And it was. But more than a dozen states have rescinded their applications. And so there are real problems with the BBA that I'll come back to in a second. But the correct count probably is about 18, but it could be as high as 22. So someplace between 18 and 22 states have valid applications. And the people at Fox News they're unnamed experts. Rob Nadelson, who's the top expert in the country, wasn't consulted. And I wasn't consulted. And any of the people that really know anything about this weren't consulted. And by the news sources. And so anybody that knows anything about it, include the people that are running the balanced budget amendment, think they're wrong. And so, would we wish it was? Yes, we wish it was. We'd reach 34, because now we have a convention on balanced budget amendment. That'd be good. And people would stop being afraid of the process. But it's not true, and it's not going to happen. The problem with the balanced budget amendment application is this. They've been written all over the map in different ways. A lot of them say, for the purpose of proposing a balanced budget amendment. Oklahoma has an application that says, for the purposes of proposing a balanced budget amendment by reducing spending only. Well, that's different than just proposing a balanced budget. Florida passed one in 2010 that was proposing a balanced budget amendment worded exactly like this. Well, that one doesn't account for anything other than one. Florida doesn't get legitimately counted in the 18 or the 22 or the 34 because it's a class of one because it voted in an idiosyncratic fashion. And if we do get to 34 with the existing crop of BBA applications, there will be litigation over it, and it will take a long time because there are legitimate questions because these have been written in a variety of different ways that are all over the map. Our application is written exactly the same way, or the operative language is exactly the same way in every state. So, the whereas clauses, which are for show, they explain why you're doing something. The operative language has to be exactly the same. And our application will be exactly the same. We're not going to face this litigation problem.
Last three will be Adam Chandler, Jack Jotty, and Randy McDaniel.
Great.
My name is Brian. I'm from the state of Washington also.
Hooray, where are you from?
Kent.
Kent, all right. I grew up in Kennewick.
And happy to be from the state of Washington.
Yeah, me too.
You've answered all my questions. The one that I had held here, the last was I've had a lot of confusion promoting Article 5 because of the two efforts. People can't understand, that there's two separate efforts that are going on.
Right.
Is this going to create a problem?
Well, the two efforts that have any momentum, there's actually, I know of at least a half a dozen theories for Article 5 out there. But there's only two that are moving. There are only two that are really getting any traction, going anywhere. One's the balanced budget amendment process, and then ours. We have the BBA application process there are some grassroots people supporting it, but it's mostly legislators that are pushing that. And it's kind of, legislators alone do a lot, but without grassroots momentum, you really can't accomplish much of anything. And the BBA process doesn't have nearly the grassroots support or momentum or organization that we have. They have a staff of 1. We have a staff in Purcellville of 9, and around the country about 15. And then we have we have organized volunteers in more than 40 states. It really is building quickly. They've been at it for 40 years. We've been at it for 6 months. And our grassroots momentum is already superior to theirs. But our on-the-ground agreement with each other is we support all our Article 5 applications. So if we're both working in the Arizona legislature, our message is pass both. And we're going to see which one gets 34.
Great. And the Soros question.
Yeah.
I followed the voting going on in the Florida legislature and the various committees. So far, to the best of my knowledge, I've seen no Democrats that have voted for it. If Soros was for it, why wouldn't the Democrats be for it? There's a little disconnect there.
Well, all I can say is amen. Good thinking. You're right.
My turn again. I did want to put out kudos for David Long of Indiana. I understand. I know he's later, and I'm sure you know him well. I know that Indiana has passed the 2 bills. The first bill for the selection mechanism of the delegates, and the second bill, I believe, that goes through the duties and the responsibilities of the delegates. My question is, on your website, Convention of States, you keep a running list of where the states are in the application. I haven't seen anything yet that talks about the status of the actual bills themselves for the delegates. You can comment on that.
Sure. There's a variety of opinions on the best way to do that. My view is that you're better off doing that in legislative rules rather than statutes, in the standing rules of the House and the Senate. Because when you do that, only the legislators have a vote. When you pass a law, you are giving the governor a say. And both for political reasons and for constitutional reasons, I don't want to give the governor a say. Article 5 power is exclusively the power of the legislature. And so if, those laws are good, they're fine, they're excellent, but I would rather reinforce the legislature itself and its power. So that's why I advocate for doing it by rule. And the time to do it, the time to do it that really matters is when they actually write the credentials for the delegates. They name the delegates, they give them their instructions. And that's the time it really does need to be done. I think the other thing, really, the reason that it's necessary to do that is because of all the fear that has been levied over the years about runaway this and runaway that. And because I'm not afraid of that stuff, for the reasons I've explained here today, I believe those things, while legally valid and binding, are basically for political purposes only, and you don't really have to do them because the delegates are inherently bound by the nature of the resolution in the first place. And so I like to enforce the inherent power of legislatures and not have to get the governor involved. But, so we're just keeping track of the substance and not the delegate limitation.
Hello, Mike.
Hi.
You're doing a terrific job.
Thank you.
My name is Jackson Pensacola, and I think you've answered my question before. My question was, will you address stare decisis? And I think you've talked about that.
Okay, stare decisis is a Latin phrase for let the decision stand, meaning that the courts should follow the precedents that they've created. And that's a good rule if the precedents were correct in the first place. And you have to understand what the pecking order is. The pecking order is the text of the Constitution itself. Below that is a decision by any court, any place, any time. Below, and equal, on the right-hand split, you have prior court decision. On the left-hand split, you've got prior legislative enactments. They're both precedent of a sort, but they're subject to the correct interpretation of the Constitution. Anytime you can demonstrate that the Constitution has not been correctly interpreted, the rule of stare decisis takes a back seat, and the supremacy of the Constitution takes the front seat. And so, it's handy. You don't want to have unpredictability in the courts. And I litigated a case in my first constitutional case, cost the city of Spokane $3 million in parking tickets. Because in Spokane at the time, a parking ticket was a crime. It was a misdemeanor. And I was in law school and I filed this brief, and the judge, no joke, his name Judge Gump. And it wasn't Forrest, I think it was Wilford, but Judge Gump said to me, Mr. Law student, if you want to argue the Constitution in here today, then, just a second, Mr. Prosecutor, what's the maximum penalty I can impose on Mr. Law student? He said, 30 days in jail and a $1,000 fine. He said, all right, Mr. Law student, you've got 10 parking tickets. If you want me to impose the maximum penalty on each of those 10 parking tickets, then you just go ahead and argue the Constitution. Well, if you want to go out in the hall and make a settlement with Mr. Prosecutor for $10 a ticket, I'll give you 5 minutes to do that. Or else you can come back here and argue the Constitution, and I'm going to throw the book at you. Well, I didn't really like Judge. Not only because of his badgering of me, but his disdain for the Constitution of the United States. I don't want judges thinking that they're the supreme law of the land. But I did, by the way. I went out in the hall and made a deal with Mr. Prosecutor. And 2 years later, when I was a lawyer and I had a client who came in and wanted to challenge the parking tickets, I took out my exact same brief that I wrote for myself, took my name off of it, put his name on it. I got Judge Thompson instead of Judge Motz. Judge Thompson, the district court judge, ruled the tickets unconstitutional because I argued that they unconstitutionally presumed the guilt of the registered owner of the vehicle, and that violated the presumption of innocence. That was appealed to Judge Clark in the Superior Court, and I won in front of Judge Clark in the Superior Court, and that was appealed to the Washington State Court of Appeals. By a 2-1 vote, I won there, and $3 million of the parking tickets went down for the count, and all the parking meter scofflaws in Spokane love me. But we don't want to live in a country where there is no precedent. And we want to have some precedent. We want to be able to follow, because Judge Gump should have followed the Constitution. He shouldn't have been able to do what he did. I had cases, I had things he should have followed. And if you let judges just free from anything, you get Judge Gump. And I don't want to live in that kind of a nation. But I don't want to live in a nation where the Supreme Court thinks that its decision is the supreme law of the land. When I argued Witters versus Department of Services for the Blind in front of the Supreme Court, Justice Blackmun said to me, it was about whether a blind student could use his vocational rehabilitation money to be trained as a pastor. And the state of Washington said that violated the separation of church and state. And Blackmun said to me, well, counsel, when have we ever funded religious education before? And I said, I'm 34 years old or something like this. And I said, well, Your Honor, this court doesn't fund anything except for the state legislatures to fund things. The courtroom erupted in laughter. My co-counsel told me all you could see of Justice Stevens was his bow tie going, yeah, 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 yeah. He was laughing so hard. But there were 3 people in the courtroom who weren't laughing. Justice Blackmun wasn't laughing, I wasn't laughing, and my mother wasn't laughing. And he said, oh, counsel, you know what I mean. When we permitted the Congress and the legislatures to fund these sorts of things? When we asked me the right question, I rattled off 7 cases where the courts had indeed permitted that sort of thing. But see, that's the way they think. They think they run everything. And it's because every government in the history of the world, including the Women's Committee at church, the student body at Patrick Henry College, the Boy Scouts Council, every committee in the history of the world thinks their power is to rule the world. And the Supreme Courts think they should rule the world. And that they think they're supreme. And we need to teach them the Constitution is supreme, not them. I believe in stare decisis when it's applied with the overarching rule, a correct interpretation of the Constitution is the absolute predicate before you begin the process of understanding stare decisis.
And just very quickly, yes or no, I think
Yeah.
are you considering abolishing the need for bar membership in order to litigate in federal courts? And recall. Can you recall elected officials? That's it.
Recall I'd be in favor of. Bar membership in the federal courts, I mean, that would be jurisdictionally possible, but the main reason I'm hesitant to do that is that the bar requirements are state requirements, and the federal courts key off state requirements. And I wouldn't want to create any more federal jurisdiction over anything, because my ability to practice in federal courts comes from, first of all, me being admitted to a state bar. And I want to keep states in control of as many issues as I possibly can. I don't want to transfer anything unnecessarily to the federal government. So if the states want to do that, then that's different. I'd be open to listening to that and thinking about that. But But I don't want to start off giving the feds more power. So, all right. I guess you really are the really last question. Okay. All right.
Can everybody hear me?
Speak up, speak up.
First of all, I want to thank you. We're not really in opposition. I've heard everything you said. We're on the same team. I believe you fought hard for this country over the years, and I want to applaud you for that. And I agree with a lot of what you've said. I'm on the opposite side of this with regards to Article 5 for a few reasons, and you've actually articulated some of the same things. If you go back to when Madison, you said 1830s Madison recommended an Article 5 convention, I would go along with it then, because shortly after that, under President Lincoln, the Supreme Court ruled for the second time that we were a Christian nation. It was a different worldview. In the 1940s, this country ruled that we were not a Christian nation. So it's a different worldview. And my opposition is not because I'm afraid. It's not because I'm a dreamer, and it's not because I'm not in the fight or I don't believe in the Constitution. But basically, you've said over and over that the people in the states will choose the delegates, which will ensure that the Article 5 process and that its efforts will succeed. The reason I oppose it, it's effectively demonstrable in my mind, is the fact that Conrad Obama was elected not once, but he was elected twice, and with a majority of the people and a majority of the states. But my problem is that we've seen now twice that Conrad Obama is wrong with a majority of elected people and a majority of the states. So the same thing can happen with an Article 5 convention, and that is why I'm opposed, is because of the human element, not because of the process. Could you explain that?
Sure.
Thank you.
No problem. Thank you. Thank you for the nice things you said. My basic response is, you have no answer. You have no plan. You have no alternative. You've introduced the human factor, and you say, therefore, we do things that are ineffective. There's no effective process other than this. Second, look at the California election in 2008. California voted for Obama. On the same day, in the same state, in the same election, they voted to preserve traditional marriage. The people look at issues differently than they do at candidates. And we win on these issues. You ask the American public, you want a balanced budget? Yes. You want to limit the power of Congress? Yes. Do you want to limit the power of the Supreme Court? Yes. We win on issues, even in California. We did a survey on the sovereignty is one of the things that we would deal with in this. We did an analysis of people's view of the sovereignty of the United States. Should treaties be used to control the domestic law of the United States? And one of the subgroups that we tested, do you consider yourself a citizen of America, a citizen of your state, or a citizen of the world? About 7% of the American public said they believed that they were citizens of the world. And a majority of the Americans who identified themselves as citizens of the world didn't want international law being used to control the domestic policy of the United States. You take AFL-CIO workers, by the way, the AFL-CIO joined with John Birch Society and Eagle Forum to defeat an Article 5 commission in the past, just saying. But if you take AFL-CIO members, they strongly support the sovereignty of the United States. You do issues rather than politicians, you get a different answer. Secondly, we keep sending absolute horrible candidates. You send a Democrat and a Democrat-like, or you send a leather Democrat and a Naugahyde Democrat, and a fake, John McCain is a fake Democrat. He's not a Republican at all. Romney is a fake Democrat. He's not a Republican at all. You send a real conservative who has the training, background, and experience to articulate the principles of freedom, we win. When we send in phonies, because the liberal media tells us the only way to appeal to the middle is to send in somebody that looks a lot like the Democrats. That doesn't work. We've never elected a president who wasn't a Republican president in my lifetime who wasn't perceived by the public as a conservative. Doesn't mean they really were, but they were perceived by the public as real conservatives. And so we don't win Tweedledum, Tweedledee elections. It's not the right comparison. Ballot issues are the comparisons. We win marriage issues. We win these things. And again, I don't need a majority. I don't need a majority. You give me 3 million people, I deliver the victory. And I believe I can find the prophet thought he was the only one that had invented the name. And God told him, I got it. I think it's 400 that have invented the name to Baal. And I am not afraid of the American public for 2 reasons. One, I don't need them all. I just need a remnant. God's always worked successfully through remnants. And secondly, when we stand up and articulate the principles of freedom in a way that everybody can understand, and we don't do it in